अगेंस्ट हम सुप्रीम कोर्ट जाएंगे, इस ऑर्डर को हम सुप्रीम कोर्ट में चुनौती देंगे।
Welcome the judgment of the civil court regarding the carbon dating issue of the Shivling. When the whole of the area is sealed on the order of the Supreme Court, how can any activity or carbon dating can be done?
Well, this is what the Varanasi court had to say. They held back or reserved the judgment after hearing everybody, and today the district judge came there and said that no, there will be no scientific investigation. Carbon dating is rejected. Let's quickly get into it. We've got the petitioner Parul Khera and also with her lawyer Vishnu Shankar Jain joining us along with Swapnil Kothari. But quickly, just getting you the summary, will be a violation of the Supreme Court's order sealing the Wazukhana to try and preserve everything as it is. Any harm to the structure will violate the Supreme Court's orders to protect the Shivling. This is what the Varanasi court's reasoning. Harm to the Shivling will hurt religious sentiments, lessen the chances of resolution, is what they have said. Now, harm to the Shivling, that's what he has come out and said. Sometimes it's not just what the order says, but also how the order has been written and what the tone of the order is could have an impact. Over to the Supreme Court on scientific investigation is the big question. Let's go across to our panelists straight away on the Gyanvapi case. Parul ji, namaste. Aaj ka jo order, what have after the order today, how would you respond to it? Or what was your first reaction?
Anandji, I'll tell you what. On the 21st of July 2022, we have moved to Supreme Court seeking scientific investigation because we knew a situation like this may arise. That's why I was one of the petitioners in the Supreme Court asking for scientific investigation at that time. Now on 20th May, the Supreme Court had passed an order saying, the district judge has all the powers to take an action. And today this order had come. So it is a kind of a pendulum situation where, High Court is, Supreme Court is moving us to the district court, and district court is now saying that there's an order which is, is passed by Supreme Court. But however, the positive point in all these things is that the district court hasn't questioned the scientific investigation or if the carbon dating or any other procedure may done, or if there is a need of it. I mean, or there may not be,
where the court
need of it. So it is very specific that there is no question mark on the scientific investigation, but on the order which is passed by the Supreme Court.
But Vishnuji, this is what the court says. Court notes that at this point in time, the carbon dating is not required to look at the matters of due process of law. That is also something that the court talks about.
Yeah, Anandji, but
Vishnu, I would like to tell it very.
Yeah, Vishnuji.
See, Anand, I would like to tell it very candidly that the order passed by the Honorable District Court of Varanasi is erroneous in law as on fact for two reasons. First reason is, as I point out, that the Supreme Court on 20th of May had asked the Honorable District Judge to do the entire trial as well as to decide all the applications which are filed in this case. The second point is that we had moved to the Supreme Court. The Supreme Court asked us to approach the trial court. And the third point is that the Honorable District Judge has commented that this kind of scientific investigation or carbon dating cannot be done without calling the ASI. The ASI was not called for. The director of the ASI is saying that yes, this kind of an exercise can be conducted without damaging the Shivlingam. And the point is this, Anand, that please try to understand the misnomer which is being tried to be created by the Muslim community. We had asked for GPR survey. In GPR survey, no damage will be caused to the Shivlingam. We had asked for excavation of the Vazu area. In excavation, no damage will be done to the Shivlingam. And third, we had asked for carbon dating of the other constituents of Shivlingam, which means when excavation will be done, whatever will be found beneath in which there will be carbon content, for that carbon dating will be done. So first stage of this scientific investigation was GPR survey. आज मैं आपसे क्वेश्चन पूछना चाहता हूं आपके माध्यम से, आनंद, सारे लोगों से, अगर आज इसकी खुदाई होती है और नीचे शिवलिंग का अर्घा मिलता है, There is no sane person in this world will say कि इसकी कार्बन डेटिंग कराओ या इसकी आर्गन डेटिंग कराओ. जब शिवलिंग पूरा विद अर्घा के साथ मिल रहा है, that's the end of the story.
But
so you are not asking, we are asking for excavation. We are asking for GPR survey, and the last stage was carbon dating or argon dating or other techniques. The ASI is ready. The court is not calling the ASI to take its response. The court says that we are barred by the judgment of the Supreme Court. The Supreme Court says you go to the trial court. So the point is this, that Anand, this is an erroneous judgment. We'll challenge it in the Supreme Court, and I have full faith that the Supreme Court will set aside this judgment, and someday or the other scientific investigation will be done. And Anand, my last point is this, just last 30 seconds.
Please take your time.
If one side is saying it's a Shivlingam, the other side is saying it's a fountain. The Muslim side till date has gone on record and said, for the first time, they may have told various statements on media channels, but in my case they have gone on to say that no, this is a fountain and it needs adjudication. Please read their application, please highlight their application. The Muslim side themselves say that it needs an adjudication, and when we say it has to be adjudicated, they say no. कोई लॉजिक नहीं है आनंद. साइंटिफिक इन्वेस्टिगेशन ना हो, इसके लिए कोई लॉजिक नहीं है.
Correct. तो वो तो कोर्ट ने भी नहीं कहा कि I understand your pain and your agony, but the court has also said that ordering ASI for carbon dating won't help it in answering questions of law involved in the suit. Now that is where, when we were speaking to Subhash K. Jhaji, and he was saying कि सवाल तो शिवलिंग का है, सवाल तो कि वहाँ पर आस्था, which was what was the character of that place in as of places of worship act. तो वो तो law भी, scientific investigation will prove a lot of aspects of law. But how would you respond to what the judgment says, Vishnu Jain? Before I bring in Swapnik Kothari, yes, Vishnu Jain. See Anand, the point is that we are not asking for scientific investigation to prove the questions of law. The questions of law will definitely be decided as per the judgments and various catenas of ratios of laws by the Supreme Court. Questions of law are never decided on questions of fact. We are here going to establish facts. Right. Then we will prove our case through clinching evidence, historical as well as scientific. Then the point will come, what is the question of law to be framed in this case? That is point number one. The point number two is that, Anand, you will remember, and you had covered this on ground also, yes,
that this kind of survey we had asked for when we were taking advocate commission.
Correct.
At that point of time, there was a huge hue and cry in the country that why do you need advocate commissioner survey? There is nothing in this mosque. You need not enter inside. But we entered inside and we found so many things.
Correct.
In the same manner, I am telling that when this scientific investigation will be conducted, the truth will come out. And let me tell you, Anand, this kind of, and please give me 10 seconds more.
Please.
This kind of an order is not new. This kind of order was passed in Ayodhya's case. This kind of order was passed by civil judge of Varanasi, Honorable Mr. Justice Ashutosh Tiwari, asking for GPR survey and the ASI survey of the entire premises. The Muslim side is an appeal before the Allahabad High Court. So we got a very narrow window where after that order, the commission was done. The Shivlingam was found. The Supreme Court permitted us to move to the trial court. And therefore we asked for excavation of the Wazu area. Now this is our case as a whole, like in long and short before you.
No, I get your point. That, but the tone of the judgment, is that an indication where the judge says there is merit in what you are asking for? We can, but I don't want to take the responsibility of allowing it, because I don't want to be responsible, or this court does not want to be held responsible if something happens tomorrow, because the Supreme Court has said कि इस जगह को कुछ नहीं होना चाहिए. Swapnil Kothari, quick comment.
Yes, Anand, this is a very, very absurd judgment. It lacks complete application of mind, as we use, to use the legal terminology. And I'm sure the Hindu side will go ahead before the Supreme Court for seeking a clarification of the interpretation of its order. to challenge this order before the Supreme Court may perhaps be another technical flaw, because you need to go to a higher court than the district court, which would be the High Court, and then you go to the Supreme Court. So I would not put up an appeal or a challenge to this order in the Supreme Court. If I were there, I would put up a clarification before the Supreme Court, and the Supreme Court might just say that let us clarify our laws, our order should not operate as a bar. It was an erroneous interpretation by the district judge, and it needs to go straight back to the district judge again for a recall of his order, or whether he wants to revisit this order. But looking at the tone and the tenor of this judgment, having said that, the first part, the second part is looking at the tone and the tenor of the judgment. I don't think that this particular court was inclined to pass a proper order, in the sense that it did not want to adjudicate upon it. It found two reasons to do so. That first of all, it was the Supreme Court's order was an embargo, which was an erroneous interpretation of the Supreme Court order, because on the 20th May itself, the Supreme Court said that you should go ahead with the applications, and once the Supreme Court shunts it back to the trial court, which it did on that day, that means the trial court was seized off by this matter with the jurisdiction, with complete jurisdiction to dispose of the applications as it deemed fit. It did not do so. Now, the second point in this, the key part is about the carbon dating part, which it did not say that carbon dating is something which is, some of your panelists earlier during the day, or, people across the channels have been saying that carbon dating may not be the adequate method. But, that is not the issue before. That was not the reasoning by the judge. The court did not even go into that.
No, because the court very clearly was apprised, Swapnil, and I'm reading the order. Carbon dating athwa anya vaigyanik technique. So the court also accepted that it is any other vaigyanik technique. And you know what? And it says अन्य वैज्ञानिक तकनीक जैसे कि ग्राउंड पेनिट्रेटिंग रेडार का प्रयोग करते हुए दिनांक 16 मई 2022 को अधिवक्ता कमिश्नर द्वारा की गई कार्यवाही के दौरान पाए गए शिवलिंग की संरचना, प्रकृति और आयु का निर्धारण किया जाए. Now in the judgment,
one point I would like to make for the benefit of your viewers is that when a trial court in a civil suit is seized of the matter, the first point before any questions of law arise are questions of fact. The questions of fact need to be established. This is a factual question, whether or not there is a shivling or whether or not there was a fountain. For that purpose, the court is free to order an inquiry, whether it's scientific, non-scientific, excavation, etc., whatever it may deem fit. To say that it could damage the shivling, any scientific inquiry, or even other than carbon dating or anything, is an erroneous interpretation, for the simple reason it is lacking, or it is undermining the intelligence of the people who would go ahead and conduct the scientific inquiry.
I am just saying
this is where it goes wrong.
In that one paragraph, there are 4 lines. One paragraph before the final order is pronounced. आदेश के ऊपर का जो बड़ा paragraph है उसको पढ़िए विष्णु जैन. Everywhere, nowhere is the Fawara mentioned. What is mentioned is Shivling, Kathit Shivling and Kathit Shivling. One place it's Shivling, one place it's Kathit Shivling, the other place is Kathit Shivling. So that's where the tone of the judgment comes out. The reference is not as what is claimed by one group which says Fawara. It is the reference is as one group said we found it there as a Shivling. The point is that the judgment turns around. Does this also say that, okay, let the top court only decide once and for all if it is, and how this scientific investigation will do it and who will be responsible for it? Let the top court decide. If I decide, then you will go to a high court, then you will go to the Supreme Court. Let the top court straight away decide, Vishnu Jain. And you have said you are going to approach the top court.
See, Anand, I have said that I will approach the Supreme Court, and the reason is this. The reason is this, that the Honorable Trial Court has said that we are barred, our hands are tied because of the judgment of the Supreme Court. Now, if I'll go to the High Court also against this order, the High Court will say that our hands are also tied because the Supreme Court has sealed the premises. So, I have to take a clarification from the Supreme Court. That is point number 1.
Correct.
Point number 2 is this,
right.
that kindly see, Anand, today I made a statement that I want to approach the Supreme Court against this order. Many questions were raised against me, Anand. When Muslim side challenged the order of Civil Judge Senior Division, which is lower than the district judge, of sealing order directly in the Supreme Court, no questions were asked. So the point is this, Anand. My point is this, kindly try to appreciate. I am the person who did this advocate commission. The entire survey was done. When survey was done, we said on record on your channel and various places on record, we said that Shivlingam has been found. If today I was not good with my conviction, I wouldn't have made an application for a scientific investigation. Because if it's a fountain, then definitely fountain will come out.
Correct.
The theory of fountain will come out by the ASI. The ASI will say that, boss, you are wrong. This is a fountain.
Correct. The point is, it has to be determined eventually by a third party which will authenticate via all scientific means, which will prove beyond doubt whatever that. Now, there is another suggestion: 3D X-ray / scan from the side or top. They do that for pyramids, and there will be no harm for Shivling. Another viewer who's watching it, and he's a professional himself, who said that this can be done. So, Parul Khela, finally, it is at the doorstep of the Honorable Shivling of the Honorable Supreme Court. Do you believe that the path to scientific investigation will be cleared there?
See, Anand, truth will prevail. मतलब सत्य तो सबके सामने आएगा, धर्म की जीत तो होकर ही रहेगी, सत्य सबके सामने उजागर होगा. See, there are historical evidence, there are documentary evidence, there are religious evidence. Now, what is left? The only thing we are left now is with the scientific investigation, and it will happen, because without that you can't ascertain if it is a Shivlingam or a fountain or whatever it is.
Right.
I mean, we'll have to go through that route only.
Well, let's see,
So
and you may just have the new Chief Justice presiding over it. We don't know, but it will be there in the Honorable Supreme Court of the country that this matter will be decided, whether or not there will be further pursuance, the scientific way to settle this, whether it's a fountain or it's a Shivling. What the judgment intends to say is, let the Supreme Court decide. So it's over to the top court now. Vishnu Shankar Jain, Swapnil Kothari and Parul Khera, thank you very much. Winding up the right stand on that note, ladies and gentlemen. Zakar Reddy with Brass Tacks.